to another edition of Ask Michael Eline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey, I'm super glad to have you back again, Alan. Everybody, this is Alan Beck. He's one of the preeminent Second Amendment rights lawyers in the country, and he's going to be on today to talk about a case that he argued at the Ninth Circuit about, I think, 3 weeks ago now. Alan, is that about right?
That's about right.
Yeah, and he's going to talk about the procedural posture and how it got there and the parties and what all the different issues are. And we're going to give you a chance to actually watch these judges, these appellate judges, and the state and the and then Alan's side. And well, I'm just going to go ahead and let you start talking, Alan. Tell us a little bit about what's going on here with this case, Wolford v. Lopez.
Hi, Mike. Thanks. Wolford v. Lopez is a case that deals with certain prohibitions that were put in place after the Bruin opinion required national carry that struck down May issue jurisdictions, I should say. Afterwards, a number of states across the country put in laws which prohibited carry even if you had a CCW in the vast majority of the respective states. In Hawaii, a law was passed called Act 52, or Senate Bill 1230, that prohibited carry in dozens of locations, but probably most at issue in this litigation. Even if you have a concealed carry permit, you can't carry in a park, a beach, a bank, a restaurant that serves alcohol, and just any establishment that serves alcohol. And there's a requirement that you put up a sign if you're a private business owner to allow an individual to carry inside your establishment. And what that means is that if you own, let's say a donut shop, and you want people to be able to carry, you have to put up a sign that says guns are allowed in this establishment. Now, that's an issue for a lot of people because, firearms are a very contentious issue in this country. And they simply, most people don't want to hurt their business by putting themselves in a position where they have to take a position on a very contentious issue. So what we did was, a few days before the law was about to go into effect, myself, my co-counsel, Kevin O'Grady, filed a temporary restraining order, which is a way to get very fast relief in certain types of cases where you can't, you need immediate relief or else you're going to be irreparably harmed. So we filed in the United States District Court for the District of Hawaii a temporary restraining order and a complaint. And Kevin and I requested an injunction of all those issues. And there was one other issue that I forgot to mention. The parking lots of most locations were also prohibited under that act. And, so where there was overlap between the place we were challenging and various government buildings or other places with parking lots that would impact our clients. For example, if you're at a shopping mall and there happens to be a establishment that serves alcohol, our reading of the statute is the entire parking lot would be a sensitive place, including if you're going to a location of business other than that restaurant that serves alcohol. So we challenged the parking lot location as well. So in the trial court, we received a restraining order against the laws we issued that we went up against. We challenged. And later we had that converted to a preliminary injunction due to a stipulation that we received with our opposing with the state. And we took that up on appeal, or I'm sorry, the state appealed the trial court's opinion and took it up to the Ninth Circuit. So what you're about to see is the oral argument that have a very lengthy briefing on. And so how that works is, first, the state files a written brief because they lost in the trial court. So they're the appellate. So they go first. After the appellant files their principal brief, 7 days afterwards, there's amicus curiae briefs are eligible to be filed. And those are friends of the court briefs. They're supporting the state's position. So the state received several briefs that supported their legal position. And then a few weeks later, we filed a brief in response, and that's called an answering brief. And both these briefs are fairly lengthy. In the Ninth Circuit, you have a 14,000 word limit, and the amicus briefs are 7,000 words. That's a lot of reading for these judges to do. And then, of course, they have to review the record, which we file in a bound form, the relevant parts of what occurred in the trial court. And we submit that, and it's called the excerpt of records. And after we filed our answering brief, the state was allowed to file something called a reply brief. And that's a shorter brief, but still pretty lengthy. It's about 7,000 words is the limit for a reply brief. And then in this situation, there was no supplemental briefing. And so after we got done with those three briefs, and of course we had amicus briefs come in for us, which were due 7 days after our brief was filed. Then, of course, we had the opportunity to inform the court about what was going on over the course of Second Amendment, what was happening across the country in terms of Second Amendment litigation. And we would file something called 28J letters, or notice of supplemental authority. And those are short 350 word or less letters, which allow you to take the position on a case. This is what happened in this case. This is how we feel this case is relevant. And, then we attach case. And because it's an ongoing area of litigation, we filed quite a few of those. And so after all that was done, we had oral argument. And as is always the case, the appellant went first. And here, this is the former Solicitor General of the United States. He is a very accomplished attorney, and the state hired him to present argument actually they hired his firm and a nonprofit to litigate the whole case. And because he's one of the most accomplished attorneys in the country, if not the most accomplished at appellate advocacy, he took the lead, and he presented an argument on behalf of the state of Hawaii. And since he went and tried to argue that the trial court got it wrong, as we see here.
And really quick, I just wanted to point out, Alan, for the audience, that this is a former Solicitor General for the United States federal government who's being hired by the state because he's so good to represent their anti-Second Amendment point of view. Is that a fair statement?
Yeah. He's a private attorney with a very large law firm, and he occasionally is hired by the state of Hawaii to represent them to defend their laws.
Okay.
He was my opposing counsel in a separate case called Young v. Hawaii, and he's also my opposing counsel right now in a case called Teeter v. Lopez, which is a challenge to Hawaii's ban on butterfly knives.
Got it.
So, it was, it shows the lengths that the state is going to defend their laws. It's not just the gentleman that you see right here. He also has a large group of very accomplished attorneys in their own right that support him and take care of. I don't know how the work is internally done, but I presumably they take care of most of the writing. And the lead counsel in the trial court was a former Supreme Court clerk that went to Harvard Law, was editor of one of the journals at Harvard Law, and then went on to clerk at the U.S. Supreme Court. So some of the other counsels are all, Yale and Harvard grads. I mean, these are that for the most part clerked for either appellate judges or the Supreme Court, both. So these are the creme de la creme. I have, in terms of their legal ability, I mean, these are elite attorneys, and that's the nature of civil rights litigation.
Wow.
Whenever someone is trying to represent regular people that want to, they're fighting for their rights. It ends up typically being a guy like me, a sole practitioner that is going up against the giants of the law, because the state will always have the resources to hire these mega firms that, billion-dollar mega firms that in their own way hire, the creme de la creme of the law. But, I'm proud to say that I've gotten a lot of, got a lot of social change in Hawaii despite that, and, I'm every day of my life, I'm trying to perfect my craft, because I know these are the attorneys that the state has the resources for. They have an unlimited budget, which means I have to work hard every day. I'm reading Second Amendment cases every day. I'm trying to make myself a better attorney, because the reality is, if there's only a handful of attorneys in the country that are willing to take these types of cases, and if we falter, it's the government's got to take more and more of our rights away, and that's just the way it is.
That's the way it is. So now we've sort of laid a foundation, Alan. I don't know if you know all these judges' names, but it looks like it's a pretty diverse panel. And we have we have like part of the podium cut off there, so I'm assuming that he's facing the judges just the way that the image looks. I'm just trying to lay this out for the people in the sidebar. By the way, thanks everybody in the sidebar for coming. Scrubzilla and Chevy and Age Go and whoever else is there, Roger Bond. Thank you for coming. But is that a fair statement that he's facing those?
Yes.
Okay.
My friend on the other side, my opposing counsel, is facing them. There's a podium with a microphone, and he's facing them.
And for everybody else, like, this is super impressive, like, especially to me, having done state appellate work, to see a friend of mine who also happens to be a former Marine arguing Second Amendment cases before the Ninth Circuit. It's like a super big deal in my profession. And it should be for all of you to have this opportunity to see this happening and having someone who's actually participating in living history doing this. So please give me a bunch of ones for everybody. For Alan, I know he just got done doing jiu-jitsu class and he's probably tired. So give him a bunch of ones in the sidebar. Let him know that you appreciate him showing up. And I'm going to go ahead and start playing this, Alan. And obviously, we're not going to play the whole thing, guys. So Alan's going to ask me to speed it up from time to time. We just want to give you an idea, maybe let the judges ask the parties a few questions and stuff like that, and let Alan talk too, and let you see him argue. Here it goes.
Thank you, Judge Sung, and may it please the court. Neil
We're
Caccione.
waiting for your clock to be reset. There you go.
Okay.
But go ahead and let me know. Are you planning to reserve time for rebuttal?
Okay, yeah, I plan to reserve 5 minutes for rebuttal.
Okay, and then your opposing counsel are not quite ready yet.
Oh,
So you can just hang on.
So is that you back there, Alan?
No, that's my co-counsel, Mr. Kevin O'Grady.
I think you just walked past him and sat down, maybe.
Yeah, that's correct.
Okay.
thank you, Judge Sung, and may it please the court. The district court here imposed an extraordinary injunction enjoining the state's legislation on carrying guns in bars, restaurants, beaches, parks, and banks, as well as from enforcing its private property default rule. The public interest and balance of equities strongly favors the state, and the injunction should be vacated. The district court here essentially demanded historical twins despite Bruin's statement to the contrary, and even when Hawaii provided those twins, the court dismissed them due to arbitrary time period, geographical, and population threshold requirements. The simplest way to see this is to pick on something Judge Graber just asked a moment ago, and look to a key example the Supreme Court used as a historical analog, a settled sensitive place, legislative assemblies. They were a whopping 2 historical laws in total from just one of the 13 colonies. That was enough, the court found, because there were no sources at the time saying those restrictions were unconstitutional. So too here with each of our analogs, and we have a lot more than 2 of them. A similar problem infected the district court's analysis of the private property default rule, which does not ban firearms on private property. It simply elicits the preferences of the property owner. Finally, it's worth a pause to just think about the extraordinary arguments voiced by the plaintiffs. In the last case, they just told you that schools are not sensitive places. That, to put it mildly, is absurd. That was one of the examples the Supreme Court offered. This is a radical theory. As Justice Scalia might say, this wolf comes as a wolf. We think the district court.
And then, Alan, just let me know if you want to narrate anything or sort of, because a lot of the people don't really know some of the things that he's talking about here. So just anytime.
I think to put his argument in context, important to note, there were 2 cases out of California that were argued immediately before us that we're dealing with the exact same issue, because California, immediately after Hawaii passed, a few months after Hawaii passed its law, California passed a very similar, almost identical law. And the court, there was a preliminary injunction filed there. The trial court in California enjoined the law at issue, and that went up to the California appealed the decision up to the Ninth Circuit as well. So we all got heard on the same day. And so my colleague that's arguing, he's referencing the California case, which was decided argued just immediately before us.
Okay. And so basically the argument is, because I want to, in a nutshell, kind of tell the people in the sidebar what's going on in the audience in general. So, and correct me if I'm wrong, or tell me if I'm right, Alan, is that basically, I know in California, at least, Newsom and the legislature basically wanted to declare pretty much everywhere a sensitive area. Is that like a fair statement? Like you can't carry a concealed in a sensitive area, but almost everything becomes a sensitive area under this law, right? Where you like automatically you're barred from carrying your firearm into a business. It's automatic. Whereas in any other situation, they would have to put a sign up, no firearms allowed, right? It just automatically made it basically impossible to conceal carry, right?
Yeah, effectively. I mean, the law that I talked about in Hawaii has a twin over in the California legal laws, and you have to put up a sign if a person wants to carry, and that law has been called the default rule. And you'll hear, there's a alternative name called the vampire rule, which is not one that I use, but I have several colleagues that call it that. So if you hear either the vampire rule, and it's called that because vampires need to be invited inside a home. So you need and since here you need to have a sign inviting you, they call it the vampire rule. And it's also called the default rule because, it's important to have fun in the law. And I applaud my colleagues that came up that moniker. However, I refer to this as the default rule because as a shorthand for the signage requirement, because it flips the default rule that there always has been in the United States that says that the default is if an area is publicly accessible to the general public, even if it's private property, you have a right to carry in it, unless you're expressly told by that private. Nice one, Scrubzilla. But unless you're expressly told by the private business owner that you can't carry. So it switches the default here. So
that's the idea, though. So basically you have the the two blue states trying to flip the rules, the traditional rules, into a new rule to try to get around the Supreme Court recognizing that people have the right to keep and bear arms. So now right.
I'll get into that once we get to my portion of the argument. We've illustrated that pretty succinctly through some maps we had produced in the record. I'm going to wait until we get to my portion of the argument before.
All right. So I'll let him go, and then eventually I'll probably just say, summarize what this dude is saying, because I want to get to my buddy Alan talking. Right. So here we go.
Yeah.
Got things wrong because it adopted basically what this court in Perez-Garcia called a divide and conquer approach. The amicus brief by Mr. Charles really explains how the district court was just nitpicking example after example and missing the forest for the trees, imposing all sorts of restrictions on what counts as a good enough example. And we don't think that has fidelity to the historical record as the school's example of the Legislative Assembly one shows.
I'd like to ask you about the private property issue, which I find sort of different from the other types of restrictions in both of the statutes that we're considering. And it does appear that at least one of the statutes from the 1700s was enacted for the purpose of preventing poaching. Does it matter what the purpose of the statute was? And if so, how does that historical example assist you?
Yeah, so Judge Graber, we have a lot to say about this, both with respect to the preliminary injunction standard you asked in the last case, but also with respect to this specific law and these specific examples. We do think purpose is relevant, but as the testimony shows from Professor Hertog, there are often statutes with multiple different purposes. And here we have dead ringer statutes that are not limited to poaching or hunting. Let me read to you the 1763 New York statute, Judge Graber. And by the way, we think the Second Circuit got everything in Antonick right.
So Alan, to me, it looks like he's just struggling so hard to find some ancient gun law that supports the state's position. Is that what it sounds like to you?
Well, in the Bruin opinion, the Supreme Court said what you need to do to justify a modern day law is find a historical analog. And so what that means is that's exactly what you need to do is find a colonial law that is relatively similar to the laws at issue in litigation, in whatever it is you're litigating. So,
Good luck.
yeah, so we're trying to find examples in this case of, for example, the bar bans on carrying guns in bars, because one of the issues is places that ban carry where there's alcohol being served. And it's so there, so that's what he's doing is he's citing to some colonial laws that they are pro-offering support their position. This is a historically justifiable law.
Makes sense. I'm going to keep playing it. Sometimes I ask you questions about stuff because I know some of these people might be like deer in the headlights because they don't practice law and stuff. So I just want to make sure people know what's going on. Everybody give Alan a bunch of ones for coming and volunteering some time tonight to share with us what he does for his livelihood and his passion.
Except for the private property default rule. And we think there are important factual distinctions for why you won't have to prompt a circuit split. And I'll explain all of that in a moment. But just to answer your question about the purpose, the 1763 law makes it unlawful to, quote, carry, shoot, or discharge any musket or other firearm whatsoever without license in writing first had and obtained from that purpose from such owner or proprietor. Now, the law also says on its face it's intended to address, quote, the great danger to the lives of His Majesty's subjects imposed by guns on other property, including grievous injury to the proprietors. So this is a law about exactly the same thing that the private property default rule is about. It's about protecting property owners and vindicating their property rights. 1771 New Jersey, Judge Graber, makes it a violation to, quote, carry any gun on any lands not his own and for which the owner pays.
So basically, guys, just to kind of, because I want to move forward here because it's getting late, and I know Alan is working on briefs and stuff as well. So anyways, thank him again for coming, but with a bunch of ones if you can. But Alan, just if you could just sum up what he's saying for the audience and what his argument is. We see that he got lucky and found a case that may or may not support his point of view. I'll fast forward to try to find you, but you sum up while I'm doing that work.
Yeah. So, it's what he's doing right now is he's trying to show that there were colonial laws that banned the carry of firearms on private property unless you got express permission to carry. And that's just, we don't think that's true. It's we just don't. I mean, that's something that we extensively briefed, and I don't really think that your viewers are going to want to hear my views on a Pennsylvania law from, the 1760s. But I mean, I've looked at these laws, and most of these laws dealt with poaching, dealt with, right. Something that, where maybe there was a firearm at issue, but they weren't banning the carry of firearms for self-defense. They were banning some other, yes, and right. But, that's the job of a lawyer, is to advocate for your client. So, and you know what? He, my colleague on the other side is, he is doing his best to advocate for his client. That's the job of a lawyer.
Yeah. Well, here we go. I'm going to go ahead and blast away. Here comes Alan stepping up to the batter's cage. Hey, batter. Here we go. Looking squared away, dude. Hoorah.
Good morning, Your Honor. And if it may please the court, my name is Alan Beck for the plaintiff appellees. With me at counsel table is my co-counsel, Kevin O'Grady, and my clients, Jason Wolford, and the associational director, Todd Yukataki, is there. I have 3 points I'd like to make. First, Bruin holds there's a general right to carry that's subject to certain exceptions. Here, the record demonstrates that 96.4% of the county of Maui of the public accessible land on the county of Maui is restricted from carry. So we know from Bruin that the island of Manhattan is,
Sure.
we can't.
Go ahead, Alan.
So we had a architecture firm go in and see how much of the land in Maui where my clients live are impacted by the Hawaii law issue. And it works out to 96.4% of the county of Maui you can't carry a gun in. You know, that figure includes the private, the default rule that I discussed, but for the most part, that doesn't, signs, as I mentioned, people don't put up that sign. So as effectively, they've prohibited carry at 96.4% of the, right. So, I mean, if there's a fundamental right to carry, I mean, look, either A, the Supreme Court got it wrong and you don't have a right to carry. You have a right to carry and that's what the Supreme Court said. And you have a right to, it's the right. If there's a general right to carry a weapon, then it's got to apply to more than, was it 3.6% of
your front porch?
Yeah, I mean, it can't just be parking lot, the road and the sidewalk. That's effectively what that works out to.
Hey, Alan, let me interrupt you really quick. I gotta say, Ralph Riley here. So this is called Super Chat. So he just donated $5 to Team Eline for our conversation tonight through YouTube, and he's asking, when you own your land patent, it also gives you the right to hunt on your neighbor's property. Have you ever heard of that before?
I am not a property law attorney, so I don't want to speak on that.
All right. I didn't mean to interrupt you, but I just wanted to tell you, sometimes I'm going to get these. They're called Super Chats. And I'll scream it off and try to support the person because they're paying me to stay up late and talk. So, Alan, I'm going to keep on playing this video unless you have anything else to add.
No, keep playing, please.
All right.
Is not a sensitive place. It cannot be a sensitive place. It can't be that the county of Maui, which is far larger, can be deemed a sensitive place.
Doesn't it depend, though, on how the definition is? Suppose, this is a made-up example, but suppose there were an island that was 100% occupied by a school, and the definition in the statute is no carry on a school property. So it may equate to an island, but that isn't why the law applies. So if that is true, what difference does it make? What is the percentage of one of the islands that is covered by these specific provisions?
Well, it's important because this is where my clients live, and they have to live.
I understand it's important to them. I'm asking you a theoretical question. In other words, if I'm using school, and for the purpose of my question, I'd like you to assume that it's permissible to prohibit the carry or at least concealed carry on school grounds. So if a giant school that takes up a whole island exists, but the law doesn't say you can't carry on XYZ island, but rather it says you can't carry on school property, I don't understand why that wouldn't be okay, even though it happens to be coterminous with the geographic location.
If an entire island were a polling place, then I see your point, Your Honor.
Okay, so why does it matter to us what the percentage is of one of the Hawaiian Islands?
Well, because essentially what's occurring here is that for the population of Maui, and Maui is a general residential, I mean, not residential, but people live there. It's just, the vast majority of it has become a no carry area for them. And their right to self-defense is been essentially curbed down to the streets and the sidewalks. And it does matter how much it is, because this isn't a hypothetical. I mean, this is.
But the law doesn't cover streets and sidewalks per se.
Oh, no, I mean essentially everywhere but streets.
Oh, I see what
My
you're saying.
apologies. Yeah. I tried not to see it more. So the ultimate point I'm trying to make here is that this restriction
That's wild, Alan.
makes carry the exception, not the rule. And we know that's turning Bruin on its head.
Well, Hawaii consists of more than one island, so why would we look only at Maui rather than at the entire state?
Because this is both a facial and as applied challenge, Your Honor. Therefore, the situation in Maui is vital to determining my client's as applied challenge. So, Mike,
Yeah.
the record shows there.
Yes, sir.
Well, let me discuss what a as applied versus a facial challenge is.
Yes. Thank you.
A facial challenge is where you're trying to get a law struck in its entirety, and the Supreme Court has said. And, I need to preface, even though we're listening to one of my oral arguments, what I'm saying is just simply my general views on the law rather than a position I'm taking in a particular litigation. So I just don't want to be in a position where someone pulls this up in a year or two and says, oh, Mr. Beck, you said this, right? But so as a general matter, a facial challenge, you need to show that this law is unconstitutional in most of its applications, right? So it's more than just your client's situation. You have to show that typically this law is unconstitutional. Yeah. So in a facial challenge, you look beyond what your client's particular situation is, and it can be and it's a more difficult challenge to prevail on because you have to show that in most situations, this law is unconstitutional rather than just in your client's situation. Now, as applied challenge is exactly that. You're applying the law to your client's particular situation. And there's times where a law is generally constitutional in most of its applications. But for whatever reason, your client's in a real unique situation. And as to his unique situation, this law doesn't make sense. It's unconstitutional. Now, that's not all as applied challenges, but I'm saying that's why everyone's got a unique situation. And sometimes the as applied challenge is the preferable route because your particular individual plaintiff has a particular set of circumstances where a law is more onerous or doesn't make sense as applied to his particular situation. So that's why we're discussing why the 96.4% figure matters. And the reason for that is the if this was purely a facial challenge, there would be an argument that the only figure that would matter is how much it impacts the the average person in Hawaii. Whereas in an as applied challenge, we look to our individual client's position, and it shows that these particular people that live on Maui, 96.4% of the areas they conceivably carry in, it's a firearms prohibition.
That's
And
crazy.
that absolutely matters. There's been a number of cases that have come down to whether there's been a as applied or a facial challenge. And, in the Masiandro opinion in the Fourth Circuit, Judge Wilkinson is very eloquently discusses both the difference between an as applied challenge and a facial challenge. And he talks about how as applied challenges are the building blocks to our American jurisprudence. And that's because the courts are more likely to say that we can see that this person's particular set of facts are this application is unconstitutional, and whereas in a facial challenge that entails striking the statute in totem. So
Got it.
yeah. So let's continue.
All right. And then just tell me, Alan, I know you've got things you need to do. So if you need me to speed it up or you want to summarize, just let me know,
It
brother.
would be great if you could maybe speed it up a little
Long-standing
bit.
history and tradition,
When-
limiting the general right to carry in the locations challenged here. Which are
Let's
all
do,
locations that
maybe a couple
existed
more minutes.
at
Let's go forward.
1791.
How about 5 minutes, 10 minutes?
Yeah, 5 minutes.
All right. Give me a couple seconds here, right about there.
Historical tradition of keeping guns away from areas where there's a lot of people that are drunk.
So,
That's not the case in most of the locations here.
Mike,
Yes, sir.
And the gun
What's up?
so this part of my argument, the Second Circuit Court of Appeals has already ruled on New York's rendition of the sensitive places law, almost identical to both Hawaii and California's law. And that's a case called Antonyuk. Yes, in Antonyuk, the Second Circuit already upheld many of the laws at issue here, but it struck down the default rule, i.e. that signage requirement I was
Right.
talking. So this is a
Yes.
very important part of the oral argument for both myself and my colleague on the other side.
Got
The
it.
reason is the courts don't want to create a circuit split. A circuit split is when two federal court of appeals disagree with each other. And in the California case, they had already indicated my panel had already indicated that they did not want to create a circuit split with the Second Circuit. So
Copy.
what I'm attempting to do is demonstrate that the Second Circuit got it right in overturning the default rule, and was much of the argument prior. And B, that the Antonyuk opinion is distinguishable from our challenge for a number of reasons. One of those being, as you just come up to, in Antonyuk, the matter at issue in that case was broad facial challenge to places served alcohol. And the Second Circuit said that we have a historical tradition of prohibiting guns where there is a large group of people that are drunk, say in a crowded bar, right? Now, it doesn't matter whether that is true or not. What matters is the Second Circuit said it's true. And now, assuming that statement is true, and I'm saying that the Ninth Circuit does not need to disagree with the Second Circuit's analysis, because what we're challenging here are restaurants that serve alcohol. And restaurants that serve alcohol are not the same as a crowded bar.
Got it.
Now, when I was a young lad, I was a soccer player. And I would oftentimes go to a place called Round Table Pizza. And Round Table Pizza would host many of the soccer games, young soccer clubs that would come in, and they would play. The parents would eat pizza with their kids. Now, what does Round Table Pizza have to do with this? Round Table Pizza serves beer. And so these parents, on occasion, would have a beer with a slice or two or three of pizza. Now, under this law, carrying a firearm is prohibited, even with the property owner's consent. There's no way for the property owner to say you're allowed to, because they serve beer. Now, that's much different than a crowded area with a crowded bar with 100 people in it, 1,000 people, some downtown nightclub, everyone's drunk. That is the historical tradition that the Second Circuit says exists. And while I disagree with that, even if that is the case, that has nothing to do with Round Table Pizza, because Round Table Pizza does not have large groups of people that are drunk.
Right.
Rather have people that, for the most part, don't drink. That's just the reality of it. And two, when people do drink, it's maybe a beer or two with their meal. And there's absolutely no record evidence here that restaurants that the restaurants that issue this litigation have people that that typically have people that are drunk. So that's what I'm saying. This oral argument. I'm saying even if the Second Circuit's right on these issues, this case is different.
Well, and then Alan, I want to thank Ralph Riley. He's given us a couple more super chats. So he's talking about the Hawaii's original sovereignty being restored to its indigenous people, and because of that, it should be based on the Ninth Circuit. It should be based on probably natural laws, is what I would guess. And not that I disagree with them, but since we work, Ralph, I think Alan and I would have to say that we work within the framework of the system that we have in order to try to get as much justice as we can. How would you respond to that, Alan? Something like that, ancient law being restored to Hawaii so the case doesn't apply. Because if somebody tries to go by that law, they'll probably get locked up and thrown in the torture cuffs, right? As Chile would say, the torture cuffs.
The bottom line is, this is the United States of America, and it doesn't matter where you are in the United States of America. The U.S. Constitution trumps is the sovereign law, the supreme law of the land. So,
gotcha. And that's right. I mean, that is where we're at. I just always appreciate Ralph piping in because he has a different perspective that a lot of other people do have. The Amish and the original Mormons also, and the Mennonites have similar beliefs. And I just find it interesting because I believe less government is more freedom. But hey, look, I'm going to go ahead and keep playing this bad chicken because I know that you got things to do. So here it goes.
Government has not demonstrated, that has not produced any record evidence at all that these locations actually have people that are drinking. For example, we have a California Pizza Kitchen or a Round Table Pizza. California Pizza Kitchens in the record. People typically do not go there. The average person that goes to California Pizza Kitchen for a slice of pizza and maybe has a beer doesn't drink to excess. This isn't a location where people typically go and get particularly drunk. And, so if we take Antioch, assuming Antioch was persuaded this court, we can see based upon that, all the restaurants at issue here, there's just no evidence that there's people that actually were drunk there. Therefore, Antioch actually supports the opposite result for the restaurant ban, because there's no historical tradition of the state's not produced a historical tradition of prohibiting people at these types of locations where perhaps alcohol is legal to serve, or beer and wine, but it's not a place where people typically get drunk, or at least the.
What do you say, Alan? You want me to fast forward some more? Or?
Yeah, that would be great.
Okay, give me 5 minutes?
Yeah, another 5 minutes, please.
All right. Here we go.
Says, I don't give my consent for you to carry your weapon on my private property. There's no dispute that they can enforce their will on their own private property. Is that right?
Yes, Your Honor.
Okay, so the only issue is that essentially the state is requiring permit holders to determine whether the private property owner consents.
That's a large part of it. It's also a issue with the private. One of my clients actually owns a business, and there's an issue with him having to put up a sign as well. And so that's a separate aspect. That issue, what wasn't up on appeal, but I'm just saying that that is an issue in litigation, and there's other aspects as to why this ban burdens the people's constitutional rights, Your Honor.
So that's the gist of, that's about the gist of the oral argument. I mean, afterwards, my friend on the other side is allowed to file to reply to, and that's a few minutes ahead. You can see right here.
It also overstates the impact of Act 52. For example, it treats forest reserves as included as part of what Act 52 did, but
So he's just arguing in the minutia, because it seems like one of the big problems that we're having here, Alan, is that Hawaii is just filled with all these parks, and people want to be able to defend themselves within the parks. And they're splitting hairs over what a park is, what a park isn't, right? Is that a fair statement?
Yeah, and a part of our challenge is the fact that there are parks at issue in this litigation where you can hunt in, but you can't carry a gun for self-defense. Now, how does that make sense?
That's wild.
Yeah, so if you can carry a rifle for hunting, you can't carry a handgun for self-defense. I mean, there's no reason for that, especially for a CCW holder.
I got you. So, but that's the way it works. He'll open, you'll get your rebuttal, and then he gets to close. And that's pretty much the way it works.
Yes. The person that won in the trial court is always the second person. The person that lost the trial court always goes first and gets the rebuttal.
So you guys got all that. The person that won is the second person. And really quick, I got another super chat from Ralph Riley. Thank you again, man. So he's saying you need to stop playing semantics with words. Everything falls under the U.S. Constitution. There's a big difference in the U.S. and the USA, because the U.S. of A is a republic. And you know what? That is so, Alan, we should, I would love to have you on another time to talk about, a lot of people talk about District of Columbia as being a separate, not supposed to have as much power as it has. It's supposed to be limited to 10 miles square. A lot of different arguments about it, but I know that you've heard these arguments before, and I'd like to talk to you more about that in a future episode.
Maybe another time.
Yeah. And Ralph, these are questions that I want to do shows about. So anytime you want to learn about something, reach out to me, because, we did a one earlier today that was really cool. It was about the vice admiralty courts in the USA and how the colonists rebelled, in part because of those vice admiralty courts treating everybody without a trial by jury and treating them as commercial transactions. Oh, look at this, Alan. I got another $10. And this is for my son Gunner because for his yellow belt. So I was telling these guys the other night, my wife's getting upset because I'm doing all these live chats, and that I got to go get I got to go train with Gunner and stuff, and I needed to get a yellow belt, and all of a sudden Chevy whips out like $20 and helps me buy a yellow belt for Gunner, and Gunner won, dude. Yeah, dude, Gunner got his yellow belt, Alan. I forgot to tell you.
Wow, congratulations to Gunner.
Super stoked. Yeah. Man. So anyways, go ahead. You were talking, Alan. I didn't mean to interrupt. But
anyway, I mean, that's the gist of the argument. Bottom line here is we both presented our argument. It's up to the judges to release an opinion, decide which side they're going to take, and they're going to issue an opinion. Look, you can never tell. I mean, it's anywhere from 2 weeks to a year. And I've got a case appeal right now that I've been waiting since February of 2023 on. So, it can be over a year.
What case is that, Alan, that you're waiting on now?
That deals with Hawaii's registration system. We struck 2 laws in Hawaii as violating the Second Amendment before Bruin. This was, I want to say it was in 2021 that we won on that. And the state of Hawaii appealed that up to the Ninth Circuit. So we argued that in, February 14th. It was Valentine's Day of 23. Wow. And we still haven't received a opinion from the court. So, I mean, and that's a good sign. That means the judges are taking their time, they're deliberating, and they're going to release a very learned opinion. But, for the more important cases, they take longer. That's just the reality. And so I expect us to be waiting a while before we get an opinion from this court, because you know what? Whatever position they take, I have full faith that, they're weighing out the evidence. They're taking a look at the countervailing arguments. And, it's important that, it's an important issue. So it's going to be a substantive and lengthy opinion, and that takes time. So I expect this to take quite a while before, anything's released.
Well, that was really informative, and I really appreciate it that you took some additional time to explain to them the inner workings of the setup of going in there, and the winner goes second. A lot of people don't understand how it works, and I love explaining. I like to teach people the law. I like them to understand, especially American common law, and this is a great learning opportunity to see the inner workings, and you can see everybody how civil the parties are towards each other and the court, and how the court is civil back, because this is no place to be vain or to be boisterous. It's a place to calmly and quietly argue your position with civility, and sugar always gets you more than salt. Is that a fair statement, Alan?
Well, this is, I had a law professor by the name of Roy Brooks. And, something he taught civil procedure, but he also conveyed a lot about various theories of American jurisprudence in his course. And something that will always stick with me is one of the last things he said is that lawyers are the guardians of the palace of justice.
Wow.
And that's what the courts are. They're the palace of justice for the American people. And, it's important that lawyers, whether we disagree with each other on a particular issue or whether we're representing opposing parties, that we be collegial, but forward, because, we're officers of the court first, and we're in here in a federal court of appeals. It's what we say, what we do impact a lot of people. And, the Constitution is, the how to interpret the U.S. Constitution is an issue here, and it's not setting to be boisterous. It's it's the setting for quiet reflection on the text, history, and tradition that's before the court, and to advocate for our client's position.
Yeah, I get that, and also again, thanks, Ralph. Ralph says, "Don't get me wrong, I'm all for restoring the true law of God's law," and yeah, well, I empathize because I think that not so long ago we could sleep with our doors unlocked and it seemed a lot better. Well, hopefully, yeah, you're right. Hopefully, Ralph, with guys like Alan fighting for us, we might be able to turn back the tide a little bit. And that's why I support people like Alan. By the way, Alan, everybody, give me a bunch of ones if you think that Alan should set up a YouTube channel so I can start helping him create his own channel to post a lot of cool things about what he does. Give me a bunch of ones if you want me to help him do that. And come on, Alan, let's do this, man. Let's get you a channel set up. You need one, man. You should even have a book, because the stuff that Alan's done, guys, look at all these ones they're giving you, Alan, in the sidebar. The stuff that you do, Alan, it just like Dick Keller, is historic. It's, case law, that's forever, man. You're going to see that forever, those law books, and your name's in there, dude. Ninth Circuit. It's huge. That's a big deal, man. Everybody you got to know something. It is a big deal to argue even one case before the Ninth Circuit. And Alan's argued multiple cases and won before the Ninth Circuit. This guy's no joke, guys. So, Alan, I really appreciate you coming out. And by the way, he's a black belt. So this guy really, he's not just a warrior in court, but he's a warrior out of court. And I got a lot of respect for this guy. So everybody, yeah, let's free Chili. Let's get him out of there. Look at all these ones, Alan. So Alan, when you're ready, I volunteer my time to help you set up a YouTube channel. And I know that all the Team DLZ guys and all my new friends that have met me over here on YouTube will all come over and subscribe and support you. So do you have anything you want to say in closing, Alan, and we'll wrap it up?
I mean, I hope this video has been informative, and at the appellate court system is part of our tiered system of federal justice. And, it starts at the trial court, then it goes up to the appeals court, then finally you have the U.S. Supreme Court. And the vast majority of cases never see the U.S. Supreme Court. The Supreme Court hears, I think it's between, on average, 50 to 60 cases a year. Nowadays, it used to be more, but it wasn't a lot more. Even, and so the appeals courts, they hear thousands of cases every year. And the appellate court is, the final destination for the vast majority of cases. Well, actually, the vast majority of cases never leave the trial court, but if someone wants to go higher, it typically ends at the appellate court level. And the appellate courts make law for the vast majority of issues for this country. So it's important to acknowledge the appellate courts exist and serve an important function within our system of government.
That's super awesome. So everybody, this was, we're bringing it to we're wrapping it up, but tonight we learned a little bit about the Ninth Circuit. We learned a little bit about what Alan Beck does with respect to the Second Amendment in California and in this case, Hawaii, and how there's similar cases where the legislatures are trying to pass laws to basically make it impossible to carry. Now that you have the right to carry, they're trying to make it almost impossible to carry it anywhere. So it almost becomes a crime to walk out of your house with a concealed firearm, even though you have a permit, and how Alan is fighting against that and fighting on behalf of the common man and we the people, so that we can exercise our right of self-defense to protect each other and our families. And because we all know that when you need a police officer, they're always at least 15 minutes away when you need them. So we need to be able to take action to defend ourselves and our families. And Alan's out there doing that for us, fighting that good fight every day. And yeah, right, Chevy, always faithful, semper fidelis. Thank you again, Alan. We really do appreciate you. And look, guys, I'm going to have Alan on again soon. We've got other stuff to talk about. And if anybody has any suggestions for me of different topics or questions that you have for Alan about the Second Amendment, including but not limited to butterfly knives, batons, or any kind of weapon, not just firearms, think about anything it might be. I'd love to have Alan on and do a Q&A session sometime. Now, Alan, do you have anything else to say? Because if not, I'm going to close it out.
No, I think that's it. Thank you for having me on, Michael.
Okay, everybody. Well, with that being said, thank you for showing up, Scrubzilla, Tom Shaw, Diesel, We the People, Let's OTVO, Chevy. Again, thank you for the super chats. It's always really kind of you. It keeps my wife from screaming at me, telling me I'm wasting time here. So Chevy and everybody, Let's OTVO, King Braveheart, Age Go. I'm just trying to thank everybody. Roger, Ralph Riley. Thank you, everybody, for coming. And so make sure to like and subscribe. Make sure to save. Make sure to also save it to your computer, because you never know when the thought police are going to take down this channel and you want to have a copy of this. Make sure to like and subscribe to my channel and everybody else. Stay tuned for an update. I'm going to visit Chile de Castro tomorrow at the Clark County Detention Center in the morning, and I plan on being on the Delete Laws channel later in the afternoon to give you an update about what's going on with him. And also, as far as the other question you had earlier, somebody asked if I knew whether or not the judge or somebody was coming after him or trying to put him in jail for petitioning the government. I've not heard that. I don't know anything about it. Again, I'm not his lawyer in these cases. I'm an out-of-state attorney who happens to help him with some other things that are not related to this. But I will keep you posted on things that I am allowed to share with you tomorrow. Semper Fi, do or die. I'll see you tomorrow. And goodbye.